welcome to this first installment of the Keele Law After Hours research conversation, or Talking Research, a series of short interviews with colleagues from the Keele Law School about their latest research. My name is Mario Prost. I'm a senior lecturer in the School of Law, and it gives me great pleasure today to welcome two wonderful colleagues from the department, Fabienne Emmerich and Felicity Adams. So in normal circumstances, these are conversations that we would be having on campus, either informally in the corridors of the department or formally as part of our work in progress seminars. But obviously, COVID has made those conversations a lot more difficult to have. And so I'm really pleased to be able to see you both today, catch up, albeit through a screening on the internet. So let's start with short introductions. So Fabienne, Felicity, can you tell us a little bit about yourselves, perhaps a few words about your background, your past and ongoing research? And let's start with Flick.
Hi, I am Flick. I'm a PhD candidate in the School of Law and I'm a graduate teaching assistant. My PhD project it centres on, it gives like a queer, feminist, abolitionist critique on prison law and penal governance strategies in England and Wales. And I'm doing that to kind of explore how incarcerated transgender women are constituted by the system, but also how they then shape the system in turn. So yeah, that's kind of where I'm at the moment.
That's great. Thanks, Flick. Fabienne.
Hi, I'm Fabienne. So my research intersects with Flick's research. I'm broadly interested in power and resistance within prison, broadly conceived, so also kind of carcerality beyond the actual material institution of the prison, and also now looking into more this kind of dichotomy between reform and abolition. And our chapter today kind of sits within this as prison law as a technology of governmental and disciplinary power, and prison jurisprudence, so the jurisprudence around the prison as a locality or a site of this power resistance struggle. So this is how we conceive of it and try and make sense of it from an abolitionist perspective.
Great, super. Well, that actually allows me to move on to a paper that you've jointly authored and that was recently published. You can tell us a little bit more about that in a moment. A paper called Mapping the Manifestations of Exclusion, Challenging the Incarceration of Queer People. And in it, you argue that prisons as sites of disciplinary power are deeply gendered institutions that produce varieties of exclusion for queer people who tend to challenge those gender binaries that are inherent in the prison system. And then you go on to argue that legal reforms and decisions on this subject, whilst it can be helpful to a certain degree in recognizing the special needs of incarcerated queer people, are insufficient and may even have, that's really the interesting bit in the paper, I found the paradoxical effect of reinforcing these exclusions of queer inmates as both vulnerable and threatening or dangerous. And so I was wondering whether you could expand a little bit on that and the crux of your argument in that paper.
Shall I go first?
Yeah.
Yeah, so the important thing is our starting point is that we look at the prison and we look at kind of how do we conceptualize power relations and resistance within prison, and we situate that in the criminological literature. So we build on Foucault's work in terms of disciplinary power and governmentality, and the work of others, especially Eamon Carabine and Kelly Hannah Moffat, who say that these mundane strategies within the prison produce either kind of very homogenized prison populations, yeah. So this idea that and then you're always produced as either the normal or the other, and then the other is in various ways can be the dangerous, the difficult, the foreign. So the unempowerable prisoner, essentially, within this neoliberal governance strategy. And why? So for us, it's this kind of thing, and this is kind of magnified for LGBT plus people, because they really openly, if they are either they have to hide their identities because they live in a hyper masculine environment, that in which kind of sorts of this kind of expressions of hypermasculinity are to a certain degree accepted. So a certain degree of violence or aggressive behavior is accepted as long as they don't go too far. So those people have been segregated, and people who are then openly victimized, either in this very homophobic, transphobic, and as misogynist environment, are then excluded again. So you're either deemed threatening or you're excluded. The result within a prison, which is a very exclusionary institution in any case, there are multiple sites of exclusion. If you are othered in either way, you have the only response the institution has is to exclude you and isolate you even further. So if you are dangerous to others, you are segregated, and if you need protection from in violent space, you need to be segregated. So the end material reality for these people is the same, or virtually the same.
So, and you're saying that segregation and that exclusion happens even in the name of protecting and preserving the interest of queer inmates. Yeah. That is the outcome, whichever way you look at it.
Yeah. So you either hide your identity. So this is the two cases that we found in. So again, the jurisprudence there's not a lot there, and we know this, don't we? We know that the cases that actually come to court, especially in admin law, are a few. And so the two cases we have, one is a European Court of Human Rights judgment, ex in Turkey, and the other one is an Irish case, Connolly case. And in both the cases, even the European Court of Human Rights even highlighted this and said, actually, the way this person was treated is the same as Ramirez Sanchez was treated virtually, who is, the jackal, who was, a major, convicted of major terrorist offenses. So this also comes out of my research with the Baader-Meinhof group. When I looked at their kind of experiences of imprisonment, they were also isolated. So there is this thing, there is no other response. You can survive within the mainstream, or your protection is a form of exclusion. And so in the UK system, we found one case, which is the Burgas case. Again, is a case around people convicted of terrorist offences who were segregated. But what in the lead judgment, the judge said was really interesting, that actually as a prisoner, you have a right to some degree of association, so meet and socialize with other prisoners. But that is open to a very wide discretion, and they're unwilling to, because of the way the institution has to be managed and the security concerns, it's deemed non-justiciable. So they don't really, it's not non-justiciable, but it deems it beyond the scope of the court to interfere with that wide discretion. Yeah. So again, it seems paradoxical to me, and it's actually and this is why this subject is so interesting. It's because it actually shines a wide light on actually the underlying incoherencies of the institution, and that it is truly about punishment. And this is what abolitionists have said. This is what, and that it can never be an institution of care and support. It just can't.
So that's really helpful. And I was wondering whether we could try and zoom in very briefly on the sort of second part of the argument that you make in the paper, the idea that legal decisions and legal policies put in place with the aim of sort of addressing this problem are insufficient and might even reinforce it. So in what ways would you say that those policies or those decisions are insufficient? Why are they insufficient? And where is the paradox that you allude to, that they might eventually end up reproducing, or worse, reinforcing those exclusions?
Yeah, if we look at some of the case law, especially with the trans prisoners, there is in the jurisprudence itself, there are attempts maybe by judges to kind of intervene and to say, we recognize that the prison is a deeply violent and coercive space, and therefore it's probably the worst kind of place, right, that trans people particularly can be placed within. They say that, and then later down the judgment, they'll still impose their concurrent sentence with one of the cases in the chapter we talk about, or they will not challenge the culture of transphobia inherent within the prison system itself. So there'll be no attempt, even though we think about judges, right? They are inherently powerful. and they do have the power to, you know, put these kind of things in their judgments to make it known how deeply problematic these institutions are. And they do so to a degree. I guess they kind of surface level recognize it, but there's no attempt by them to then challenge that culture, which then, if we think about it, it then cements these normative relations of power, right? It doesn't prevent this heteronormative prison system. It doesn't prevent it. It doesn't enable it to change, rather, right? It doesn't disrupt in that mainstream, that continual, you know, placing people in prison. Fabienne.
So the B case was, in that sense, a judgment that could be seen as uprooting sort of the prison as an institution, and as a result there were policies developed to support trans prisoners. But again, so you have an institution that's accommodating, and this is what Flick's research is about, is the kind of these gender responsive institutions. What they tend to do, and there's research in women's prisons, is actually that they're a lot more coercive, because there's a lot closer supervision. And there's this kind of notion, and I think trans women are the kind of, it's magnified with trans women. We write about this in the paper. Women are deemed to be doubly deviant, and Pat Carlin has written extensively on this side. And they need to be domesticized. They're infantilized. You know, they need to be treated and also be taught to be good women, not just to not, you know, commit crimes, but also to be better women.
Yeah. But I was just going to say, with the gender responsive stuff as well, which we do pick up on in the paper, you know, gender responsive in quotation marks, can a prison ever really be responsive to gender? We say no, but and so do other people. But with this kind of, with some of the more recent policy changes in England and Wales, with this kind of trans prison, all of these different prison service instructions, they might initially in 2011, you know, push towards a more flexible approach to gender identification, but subsequent policies are kind of backtracking on that. We touch on briefly the changes made in 2019 and 2020. There's a real pushback on that because of certain cases which have been mobilized by certain groups in the mainstream, but also, if we look at the language that's used in the policies, they're not then inclusive. They might be, I guess, to some extent inclusive of trans people, but they're not then inclusive of non-binary people, gender fluid people, gender non-conforming people. So there's a massive gap. But, you know, these policies are there to serve these people as well, which is sometimes forgotten, isn't it? So it's this idea that the prison is this one-size-fits-all approach, which completely flattens complexity, like, period, and doesn't account for the nuances in identity at all. And in doing so, people are lost through that kind of that bureaucratic mesh. It's deeply problematic, as we talk about.
And thanks. So it's so problematic, in fact, that in the conclusion of the paper, you argue very forcefully and persuasively, might I add, that the sort of anti-queer, homophobic, transphobic nature of prisons are, to quote you, innate characteristics, right? That no legal reform can meaningfully resolve. And so the sort of endpoint of the discussion in the paper is that any meaningful conversation about the rights of queer inmates or incarcerated queer people has to involve a conversation about abolition, right? About prison abolition, or at the very least a discussion of decarceration. And so I was wondering whether you could say, by way of conclusion, a few words about that distinction between prison reform, prison abolition, and what, if we go for prison abolition, what might be some of the alternatives to imprisonment?
Okay. Good. Do you want to start as well?
Yeah, okay. So I think the kind of difference a little bit between, this is our favourite bit, so the differences between reform and abolition is this, the reformist notion that the criminal justice system, so the prison industrial complex, so all of these networks that come together, not just the prison, there is an ability to reform them. That's a reformist perspective. But an abolitionist perspective, it's more of a liberal kind of understanding of how these institutions work. But an abolitionist perspective is saying that these institutions are functioning as intended. They produce violence because they're there to produce violence. Therefore, we need to, abolish these systems in order to eradicate that violence, but not just abolish them and get rid of them, but to build new communities, which address violence, harm, healing, accountability in different ways that don't replicate that violence that the prison, by its nature, promotes and perpetuates.
Yeah, exactly. So there is this notion that, and this is a Marxist argument, it's been made for a very long time, is that, the systems are there to keep the structures, the status quo, to maintain the systemic inequalities inherent in the capitalist system. So, and we can look at the numbers, and, criminologists have been saying this since the 70s, that, from a class, gender, and also ethnic minority perspective is, we just need to look at who the system captures. So it's exactly functioning as it should, and therefore reformers think that it can be fixed. And again, prison reform and abolition are as old as the prison. So there's this wonderful story that is just sad, bittersweet, is the Quakers who helped build the first penitentiary immediately regretted that what they had done, and then started to shift across to abolishing the prison. So, and one of the counter arguments is always that abolitionists are idealists. So what? We are idealists and realists, because, to be honest, to say that the prison can care and support and rehabilitate people, it's not worked for however long it's existed, and that's an idealist perspective as well. So you need both, and what Flick has said is absolutely right. And then there is this middle way. So how do we then kind of conceptualize the work that we are doing? Are we, in terms of, if we're looking at Foucault's understanding of discourse and how power and knowledge intersect, are we perpetuating the system? So there is this notion of I've gotten, is it non-reformist reforms?
Yeah, I was going to say reformist reforms and non-reformist reforms. Exactly. That's what you're making me think of in my head. This idea that we're saying in the chapter that we shouldn't be wasting our efforts on these reformist reforms. This is an argument by Andre Gors, and essentially what that means is the distinction between them. And non-reformist reforms are reforms that help us to transform the system, to transcend the system rather, and to transform our ways of being and our relationships with things like punishment, anti-violence strategies, that sort of thing. Reformist reforms are things that bolster the existing system, things that merely kind of tweak the existing system, which are harmful, then because then we're more welded to the system. So it's legitimizing that thing that already exists. And these are not new arguments, but they're arguments made by Angela Davis, Ruthie Gilmore, Dean Spade, but they're particularly harmful for queer people who are already disadvantaged on the outside of society. But put them in prison, it's a complete it exacerbates all of those existing inequalities, isn't it? Yeah.
Thanks. That's really helpful. Listen, I'm sure that people watching this will really be keen to read the paper. So can you remind us briefly where the paper it can be found? Oh, well done. Look at this. You came prepared.
It's actually quite, we're very happy and pleased that we were included in this book. It's called The Queer Outside in Law, Recognizing LGBTIQ People in the United Kingdom. I think it really kind of highlights this binary of, including those who are deemed the compliant LGBT plus people who kind of fit within, but then doubly excluding those who are then doubly othered. And
I think this is important, isn't it, for LGBT plus History Month as well, because in the mainstream LGBT movement, those who are incarcerated are usually at the periphery of mainstream LGBT plus people's consciences, which is a real problem. So it's important for us to recognise that the increasing levels of violence, harms that are perpetuated by the carceral system, with, not just with this text, but more broadly, thinking about how not just prisons, but the police, mental health institutions, the government, this whole prison industrial complex, how harmful it is, particularly for that group. So, yeah.
Thanks. Now, listen, before we wrap up, I must ask you to say a few words about Read and Resist, right? This project that you've launched and that you've been convening for the past, 6 months, a bit more, even longer.
Yeah,
I think it is. So can you tell us a bit about what the project is and the sort of activities that you're undertaking as part of it?
Yeah, so this is great. So Read and Resist is a collective and collaborative forum that centres on transformative justice, and it brings together a host of, activist, academic, organising, community voices, all voices on aspects of transformative justice, which is this movement, a framework to look at our societies and communities as a way of transcending these violent carceral strategies and building communities which properly addressed things like violence, trauma, interpersonal violence within our communities, which don't rely on state institutions. So as part of our web platform, we do have a web platform, go and check it out. We have a YouTube channel, we have a podcast, a reading group, which is every month on a different theme, broadly centering on transformative justice, and a blog, which you can contribute to because we have an open call for contributions where we recommend, our approach with this, our vision with Read and Resist, is to kind of provide a space for people to creatively contribute without that fear of, editorial contouring, and to provide people with a space to contribute in a variety of mediums, not just, written prose or whatever, but however they're, because transformative justice isn't it, Fab? It's like this, it's a massively complex, but also really vibrant movement. So we want to reflect that in what we're doing.
So these can be your ideas, work in progress. They don't have to be polished. So we've had contributions from students on demystifying decolonization, on trying to be proactive in an overwhelming world. We've had contributions from a person, Mike Duffy, who lives with a long-term degenerative disease, and on the effects of COVID with people with disabilities. We've interviewed Kushal Sood, who's an abolitionist lawyer, prison lawyer, so he works to help people to get out. And he has developed very exciting strategies on how to deal with parole boards and how to bring in transformative justice, so community activists to support and produce community care plans, so that people can, when they are released, they can have a support and care plan that's outside of institutions that are again coercive, and very much working with IPP prisoners, so these poor prisoners who have been on indefinite sentences and are years and years and years beyond their tariffs, need to, be helped to be released. So there's
and when we talk about this as well, I think it's important to say that we're not experts on this. This is something that we are learning about, and it's in progress. I think we can speak for us both here that we're going to be lifelong students of this transformative justice movement, and that is something that is embraced by those who are party to it, because it is, it does challenge fundamentally lots of systems that we're all in the mainstream accustomed to. But I think for me, what is good for us is that we're really embracing this complexity, and that doesn't mean that it's easy or that it's something that can be, there are easy solutions to any of the problems that we occur, or any of the issues, but it's that willingness to think about other ways of dealing with that actually enrich us as well as people, which is something that we don't ordinarily do in lots of these different structures that we occupy. So
no, exactly, and this is what we did with we set off this year so this year for us is the year of the erotic. It's all about channeling the erotic in our everyday lives, and this is based on Audre Lorde's paper, you can there's the link, and also the I think the video as well on our website for that reading group. And it's really about doing that also in our working lives and in our family or daily lives. So this is kind of guiding our work. We want it to be positive and productive, and not be shouting. We are angry, but it's, as I saw a recent lecture by Carol Smart, she was saying about when she was writing Women, Crime and Criminology, it's about channeling that anger into something positive. And I think that's also good for our mental health and self-care.
Well, thank you very much to both of you for taking the time to talk to us today. It's been really good to catch up and to talk to you. We'll include all of the links to your research and Read and Resist in the descriptions below the video. Goodbye for now.
Thank you very much, Mario.
Thank you.
Bye-bye.